Now, correct me if I'm wrong, because I'm not an attorney, but Florida doesn't have its own domestic asset protection trust statute. Um,
Correct.
correct. So, how do you handle that for clients who want that level of protection? And what multi-state strategies do you typically use?
So again, it's a conversation to have with them because of the fact that over the years there has been erosion of that protection. Some of the courts are now saying that, well, if let's say we set up a Nevada trust, but your only nexus, your only ties to Nevada is you hired a trustee there and your document says the situs of the trust is controlled by Nevada law. Other than that, you have no property there. You don't you don't have any connection to Nevada other than those two things. So courts are now more and more saying, well, if you don't have that connection in Florida, where most likely this is where you live, so most likely this is where your creditor is. And Florida has actually a statute that basically says our public policy is not to have self-settled trusts or these sort of domestic asset protection trusts. So then that gives the court the ability to say, we're not giving that protection because you really have no connection to that trust. So it works sometimes, but it's important to have that conversation with them that it's not the blanket of liability protection that they may think, especially if they don't have a connection. So then from there, depending upon the circumstance, we may look to foreign asset protection. We may look at the Cook Islands, where the Cook Islands off of New Zealand has laws on their books to say, we're not recognizing any foreign judgments. Also, if you have a creditor, they would have to go to the Cook Islands, file a lawsuit all over again, find a lawyer, file a lawsuit all over again, prevail, and then try to get to the assets from that standpoint. But then again, the downside to that is you're putting a lot of faith in someone who's halfway around the world to protect your assets, right? So it's a conversation to have, but people need to go in with their eyes wide open to say, okay, I don't really know this person. Yes, it's a trust company in the Cook Islands, but what's my ability to go after them if they take off with the assets or things like that? If it's not achieving what I wanted to achieve because I have absolutely no access to the assets, things like that. So they're all good tools, but it's important to have the conversation of why is it a good tool? When is it a good tool? And does this apply to your situation?
So let's go to another situation. Someone who's got properties or business interests in multiple states. They're living in Florida, so they have Florida. Maybe they have something in Georgia or Florida and one of the Carolinas. How does that complicate the planning? And which states' rules govern what?
Yeah. So with real property is going to be the state in which the real property is. That's where those laws will apply. Um, if it's you have bank accounts, those are a little bit more fluid. That's personal property, so that's gonna be based or financial accounts. That's gonna be based upon where your primary residence is. Okay, so it's not always so that again goes back to to making sure that if your primary house is in Florida, you want to make sure you're treating it as your primary house because you have the homestead protection in Florida that you don't have in Georgia or the Carolinas that I don't think have that same protection. So you want to be careful as well that you don't spend 80% of your time in Georgia and then try to claim your Florida property as your primary residence. Okay, so you'd have to actually treat it like your primary residence. So it's not only knowing what the laws are, but it's also making sure that you treat the asset as it's intended for the asset protection purposes.
So let's help people get started now. When someone comes to you for that asset protection assessment, what does the first conversation actually look like? What information do they need, or do you need before you can actually give any meaningful advice?
So the first thing is when you call, you talk to our service coordinator who will gather some of the necessary information. So, what is the asset? How much is the asset worth? And how it's titled. Those three things, especially in asset protection, are very, very important. Also, what current creditors do you have? Because that again goes towards the conversation of, again, the point isn't to make you insolvent. The point is to utilize statutes and some of our tools to protect what we can protect, but also make sure there's what I call, a little carrot on the stick in case something were to happen. So you want to make sure that whatever asset protection we do, that you're still able to meet your current obligations. Okay, so that's a big part. So we need to know what are the creditors. Okay, and so from there, it's depending upon what the assets are, what type of assets they are, is how we start to structure or how we start to map out what is a good plan for them. Also, what is their risk tolerance? What kind of control do they want? What kind of administrative burden is okay for them? Um, those sort of things all go into that sort of conversation.
Now, in our social media, TikTok, YouTube, AI, Chat GPT world, there's probably a lot of advice floating around from a well-meaning accountant or a financial advisor that might be a common piece of advice that's not fully correct. Can you name any things that you regularly have to walk clients back from?
Well, yeah, there's a lot, of course. There's the tellers at the bank that tell people, well, just put your son on your bank account. So now there's three owners. It's not tenants by the entireties any longer. Um, and they tell them, well, that's convenient. Well, yes, now you just completely blew up that account for any sort of asset protection. But also now you've added in another person who can get into a car accident, who can get into a bar fight that then your bank account is exposed to. The LLC that is just a single member and they just say, well, I put it in an LLC. I know I'm fully protected now. Well, you're not. Or even a revocable trust. People think I have a trust, I'm protected. Well, it also depends upon what type of trust it is. If it's revocable trust, there is no additional asset protection for you that you would otherwise have as an individual. So that is the big one too, that people often have the misconception that, well, I just have a trust, so I'm protected. Well, no, not if it's a revocable trust. It's not. Or they have an irrevocable trust, but they're using it as if it was a revocable trust, as if it was their piggy bank that they can just take money out. Um, Not following corporate formalities when it comes to LLC. Not have a separate bank account for those things. Not titling assets.